Today I'm going to talk about the criminalization of excision in Canada from my perspective as a legal expert. The legal term excision is employed specifically in Article 268 of the Canadian Criminal Code, which stipulates that genital mutilation, including excision, is prohibited in Canada. In addition, Article 273 of the Criminal Code specifies that a person who removes a minor under 16 to a foreign country for the purposes of mutilation, as defined under Article 268, can be accused of committing a criminal act on returning to Canada. There are two aspects to the criminalization of excision. A person cannot perform excision in Canada, and a person who has participated in procuring excision on a minor outside Canada can eventually be indicted. If the legislator decides to classify excision as aggravated assault, it's because it's considered a violent act. In Canada, there is a scale of assault ranging from simple assault to aggravated assault, which is considered the most serious. The primary reason Canada decided to legislate is that a person's physical and psychological integrity is protected under the Canadian Charter of Rights and Freedoms and under various provincial charters. One cannot inflict mental or physical harm on a person unless it is expressly to save the person's life or prevent serious harm. At the same time, in accordance with its international commitments under the Convention on the Elimination of All Forms of Discrimination Against Women, to which Canada is a signatory, Canada decided to put an end to cultural practices that impede gender equality. Any family member of a young girl under age 16 who travels with her and arranges or facilitates her excision outside the country can be indicted on returning to Canada. To be clear, the person must know or should have been aware that the girl was to undergo excision. This article of law does not apply to a person who takes his or her child on vacation without any intent to submit the child to excision, and who discovers that a family member has forced the child to undergo excision without the parent's consent. The article stipulates that there must have been a deliberate intent or that the person had or should have had a reasonable doubt, and despite this, exposed the child to such a danger. In recent years, Canada has extended the grounds for claiming refugee status. A person who comes to Canada because she fears for her child's safety can now claim refugee status for herself and her minor child by invoking the threat of excision. If, for example, a mother decides to come to Canada because she fears for her child's safety, she could claim refugee status by demonstrating that the threat of excision is founded. This doesn't guarantee refugee status will be granted, but it can be the basis for a refugee claim by a person arriving in Canada. If a person in a minor's entourage fears she is at risk of mutilation, the usual route is to advise the Director of Youth Protection, whose mandate is to provide services and protect minors. It is best apt to take charge of a minor considered at risk, either of undergoing excision or being taken to another country for that purpose. Child protection services will not automatically remove the child from her family. Different measures can be deployed. They will usually do everything possible to maintain the child in her family and to educate the parents on the issue. Depending on their various professional bodies, social service workers, hospital personnel, nurses, doctors, school teachers, etc., can be under the obligation to report a child at risk. Professionals must verify their obligations as stipulated by their specific professional corporation and its code of ethics. It's possible that in such cases, not only are they encouraged to report the problem, but are also required to do so, and could even be reprimanded if they don't.